I have no wisdom to share, really. And my job tonight is very simple, which is to ask the chief some questions about his views on the judiciary, his judicial philosophy, and a few other topics. But before I do that, let me introduce the chief. He needs no introduction. And he mentioned to me earlier when we were standing on the sidelines, he said, keep it short. And I said to him, Chief, I spent 2 hours working on this last night, so you have to bear with me. So it really is a true honor and privilege for us to welcome you to the City Bar Association. And it's to say that it is an honor is not just ceremonial. It's deeply personal for many of us. Judge Wilson represents not only the pinnacle of judicial excellence, but also a vision of leadership rooted in humility, in service, and in access to justice. And those values are, if anyone knows him, they know the fact that these values are not abstract. They are lived and felt every day in courthouses and in communities across our state. And indeed, it is no exaggeration to say that there is a tremendous amount of enthusiasm about the Chief Judge throughout New York State judiciary and the legal profession. Judges, lawyers, court staff, bar leaders, everyone alike have all taken note of the same thing, and that is that this is a Chief Judge who shows up. He makes himself available for meetings, for events, for conversations, with court employees, with local bar leaders, with affinity groups. A few months ago, he made himself available for a meeting with a justice from the Pakistani Supreme Court. He meets with affinity groups on a regular basis and young lawyers alike. And he listens and he engages. And in doing so, he's already set a new standard for what it means to be a leader of our court system. He's done all of that while working around the clock, but let's be honest, Chief, compared to the hours that you worked at Cravath, this probably feels like a sabbatical. What is remarkable is that Chief Judge Wilson did not begin his career aspiring to the bench or even to public service. And he's been very candid about that in the past. And while many in this room dream of becoming judges by way of trial courts, his path was different. And after law school, he joined Cravath more or less by chance, as I understand it, stayed there for his entire career in private practice. And he has been open about the fact that he never really wanted to be a trial judge. And yet here he is serving as the Chief Judge of the entire court system in New York, and doing so with distinction, with grace, and with vision. The other thing I'll mention about the chief is that even though he had a brilliant legal career at Cravath, he also showed up in places that demonstrate where his heart lies. And he devoted years of his life to a complex, high-impact pro bono case in Alabama, challenging discriminatory hiring practices and helping to desegregate public employment in Alabama. And through years of litigation, he worked with experts to develop valid, fair, and reliable assessments for civil service positions in Alabama, replacing the opaque systems with tools rooted in equity and in merit. And that case didn't get the headlines in New York, but it changed lives in Alabama. And the values behind that case, fairness, equity, intellectual rigor, trace back to the chief's upbringing. He grew up in California, the son of two educators. His mother was blind, and as the oldest child of the family, he became her guide, telling her which can in the pantry held the green beans, helping her navigate the world. And that quiet, early responsibility cultivated the kind of awareness and empathy that now permeates his judicial leadership in our state court system. He's a graduate of Harvard College, Harvard Law School, served as an associate and then a partner at Cravath for over 3 decades, and in 2023, he was nominated to serve as the chief judge, and he was confirmed shortly thereafter. And his appointment was historic. He is the first black chief judge in the history of our state. But more than symbolic, it has already proven to be consequential. And amidst all of this, he remains, above all, grounded. He is the father of teenage children, and like any parent balancing intense professional demands, he knows what it means to manage high-stakes decisions, both in court and at the kitchen table. So tonight we are in the presence of a jurist, a leader, and a role model who not only holds the gavel of justice, but who wields it with integrity, with wisdom, and a full heart. So please join me in giving a very warm welcome to Chief Judge Rowan Wilson.
Thank you, Mohammed.
So let's begin the conversation. I think many of us here tonight are interested in learning about your pathway to the bench. You've told your story elsewhere, and I'm wondering if you can share that here tonight.
Yeah, I mean, it's a little hard to know where to start, and there are a lot of little pieces that kind of fit together. But you heard some pieces from Mohammed's introduction, and the only thing really that I would, I mean, it's all embarrassing, but the only thing that I would really take issue with is my leadership team travels as much as I do. They are as engaged as I am. They go everywhere. We end each weekly meeting that we have with events. And events means where, each of us is telling the other where we're going. And we usually have those on Fridays because of circumstances. We changed it to just a couple hours ago. And, everybody was telling, each other where we're going to be this week, where we're going to be the next week. And they go as many places. They listen as much. They're as engaged in everything. And it really is very much a team effort. It's not about me. It's about them. Yes, to some degree I picked them. But some of them I didn't pick, and I just recognized that they were people who were like-minded. So where do I start? So I could start with my parents and growing up in Berkeley, and they were kind of counterculture, and we watched counterculture news as well as the regular news with Walter Cronkite, and they were critical of everything, not critical in the sense of complaining about it, but critical in the sense of critical thought. So a commercial would come on, and they would ask their kids, so what do you think the point of this commercial is? What are they trying to tell you? Why are they trying to tell you that? It was that they could never leave off being educators and encouraging sort of independent thinking. So that was part of it. It was also, Berkeley in the 1960s and early 1970s was a place where you couldn't avoid politics and couldn't avoid public policy. And then the couple of, I think, seminal things were, in 9th grade, I absolutely refused to do an oral report, and the teacher asked why, and I said, just give me an F for that part of the grade. And he said, well, I'll tell you what, come back at the beginning of 10th grade, tell me why you wouldn't do it and what you're going to do about it. And, I thought about it all summer. I went back and talked to him. I said I was afraid of what people would think when I opened my mouth and started talking, and I realized that's not rational. So I've decided to join the speech and debate team, which I did, and then I did every sort of public speaking event you could imagine for 3 years of high school and the first year of college, and found I was actually kind of not too bad at it. So that was part of it. And then the other part, I pin on a single day, and there's one little piece of my biography you missed, which is I clerked for 2 years for the Chief Judge of the Court of Appeals for the Ninth Circuit, Judge James Browning. And there was one day when he and I were the only ones left in chambers. It was pretty late at night. The chambers were in the courthouse. It's beautiful, but it's in the Tenderloin district of San Francisco, and it was right across from the Greyhound bus terminal, and it's nighttime, and through the windows on that side of the courthouse, the pink neon of the Greyhound sign sort of filters in through the offices. And Judge Browning normally would not walk through my office to get out, to leave, but this day he did. He walked out, he walked into my office and said goodnight. And knowing that I was going to be there much longer than he was, it was already probably 8 or 9 at night, said, this is the best job you're ever going to have. And then he left. And he said he was a small man from Montana. He was maybe 5'5" on a good day. and with really like a leprechaun kind of look and a twinkle in his eye. And then he pops the door from the hallway back open to my office, sticks his head in and says, "Unless you have my job someday," and then he closes the door. But that really stuck with me. And so all those years at Cravath, I sort of had in mind, someday when I'm kind of done with this, there is something else I'd like to do. And 25 years in, I applied for the Court of Appeals, and I didn't get the job, and I applied again, I didn't get the job, and I applied again, and I didn't get the job, and if I can count through 6 of them, I applied, and I finally got the job. So that was my path.
So getting to the bench, not having served as a judge on the trial court, what was the most challenging thing that you encountered?
It depends if you ask me or you ask my colleagues.
Well, we'll begin with
Because
you.
they told me.
Well, let's begin with what you found to be challenging, and what is it that they told you would be challenging?
Not would be challenging, was challenging, where I was falling short.
Mm-hmm.
So what I found the most challenging were the areas, I had what I thought was a broad civil practice, but what I found most challenging were pockets of the law that didn't intuitively make sense and had their own rules around them that didn't sort of fit with other kinds of rules. If, to single a couple out, workers' comp, which doesn't make any sense to me still, but I have a little bit better understanding of how it works. I'm not sure why it works that way, but that's how it is. And the scaffold law, for example, some of the things, other things around tort law, just not common law tort law, but some of the statutory overlays just take a lot of time to learn. And I found that because they were kind of counterintuitive, and then the other place, I think, was criminal procedure, not substantive criminal law, but since I had never practiced as a criminal lawyer, the substantive stuff, it's on TV, you can kind of understand it, and from your basic criminal law course, you sort of get it. But it turned out the procedure was much more complicated, and simply reading it didn't really give you much of a sense of it. And then, to my chagrin, when I would ask Judge Fahey, who had been a trial court judge, handled criminal cases in Buffalo, or Judge Feynman from the city, or Judge Stein from Albany, they were looking at the same rules, and they all said, no, that's not the way it works here. And they each had 3 different ways that the same rule worked. So those were the things that I would say I found challenging. What some of my colleagues said was the thing that was challenging for me was that I was still functioning as a lawyer instead of as a judge. And I don't think I've changed anything. I think all I've done is sort of accepted their view and said, okay, but my client now is the people of the state of New York. And that seems to have worked for me.
So a judge who I clerked for in Brooklyn, Judge Jack Weinstein, he always was thinking about his cases. So I would come into the chambers in the morning, 8, 9 a.m., and I would have received faxes from him from his house in Long Island that came in at 3 a.m. or 4 a.m., sending thoughts that he had in the middle of the night that he didn't want to forget, and he would just fax them to chambers. What about you? Are you always thinking about the cases that you're working on, or are you able to compartmentalize the cases that are before you relative to the other responsibilities that you have as a chief judge?
Even when I'm dead asleep, I get ideas about cases. And what I learned, and this was not just from being a judge, this was in practice. So what I learned, and Judge Weinstein, whom I appeared before and I thought the world of, had an advantage over me in that we hadn't yet gotten to email by the time you were working with him. So what I learned pretty quickly in practice was, when you get an idea at 3 in the morning, do not send it to an associate. Wait, write it out, put it in the out box, but save it there, and then at a decent time send it. And then more recently I learned there's a way you can actually delay sending it. But then I also flummoxed myself, because if you do that from like your laptop, and then you leave your laptop off and go into work thinking the thing will have been sent, it's not actually sent, and then there's no way to retrieve it unless you go back to your laptop. And so I'm learning still. But I'm trying to be sensitive of the fact that if I send somebody something they think that I expect it to be dealt with immediately, whatever time of day it is, and that's not right.
So you're not just a judge on the New York Court of Appeals, you're the chief judge of our state court system, or the chief judge of New York. Can you speak a little bit about that? What does that entail?
Too much. So, I was told, well, look at the Constitution, there's 2 jobs, right? One is the chief judge of the Court of Appeals, and the other is the chief judge of the state of New York. And it's actually 4 jobs. And I did mention, when I was confirmed, I told my youngest daughter, who's now 14, so this is 12 then, that I now had 2 jobs. And she said, oh, great, do you get 2 paychecks? No, just 1 paycheck. So I think of it as 4 jobs. I think of one as the Chief Judge of the Court of Appeals, which is sort of self-explanatory, and frankly doesn't, at least because of the way I'm doing it, doesn't involve much more than just being an associate judge on the court. I do things collaboratively with my colleagues. I don't, even when we're doing things like setting the calendar or deciding if we're going to go to some event or not or when it's going to be, I discuss all those things and we kind of reach a comfortable decision for all of us about those. So there are some little things that I kind of do that are more ministerial, dealing sometimes with personnel issues in the Court of Appeals or that sort of thing, but that isn't much of an increased workload. Job number 2 is sort of what you referred to, which is administering ultimately the courts around the state. And so some of that is, I try to delegate a lot of that so that I'm not trying to assign judges in one place or another or worried about that sort of thing. If something then becomes a problem, then it tends to get floated up to me. But even sort of interviewing people to be a new SJ, supervising judge somewhere, I'm not involved in that. It's just too much. But there is, some sense in which when something bubbles up to be enough of a problem or my team wants some input on something, I get involved in those things. There's a third component, which is dealing with the legislature, and it's dealing with the legislature not just on our budget or the things that we call our program bills, which are things that we want. For example, right now we really very much would like the compensation rate for jurors to move. It hasn't been moved in 20-something years. I think it's now $40. We'd like to have it, I think, moved to 70 or 75. I think 75. So that's an example of a program bill, or the universal e-filing that we got. That's a program bill. But when I took the job, I told our new general counsel and the sort of function within the OCA that deals with the legislature that what I wanted them to do was to identify any bill at all as soon as it was introduced that the court system might have any interest in, so that we, the leadership team, could think about what we think about it, do we care about it, what do we think about it, and then if we wanted to try and get involved in the bill drafting process with the legislature, even though this is not a program bill. So the response I got was, no, you can't do that, you'll be drowned. There's like 10,000 of these. And I said, well, that's our problem. So they did that. We get a big spreadsheet, we go through it, and it really has worked quite well, but it is, particularly in the period between January and whenever the legislature goes away in June, a lot of work. And this year, I'm sort of worried about it because the budget is so delayed that the time that they can focus on the program bills and the other things that we care about is shrinking. It should have been between April 1st and June 12, let's say. We're already well into April. We don't have a budget, so it's going to be maybe a month of real work on things. So that's a piece. And then the fourth piece is things like this. It's public relations. I'm part of the face of the courts, and I think it's important that I, during Read Across America Week, put on a Dr. Seuss bow tie and go to the Bronx and read Yertle the Turtle to students. But also, go to the Court Explorers program that the court officers run, and go to the academy in Brooklyn and talk to the high school students there. Go to the Youth in Government in Rockland County, and 250 students there, and talk to them on a weekend. That's important, it's a big part of what I do. I wouldn't have to do any of it, but I think to do it right.
Which part do you enjoy the most?
The actual Court of Appeals job.
So let's speak about that. In your view, what are the traits, attributes, habits that you have that you think make you a good judge, that others in the room should try to perhaps try to emulate?
Well, you said that you mentioned that I didn't want to be a trial court judge.
I think I had heard that from somewhere else before.
You had. And so I should explain that because I think the attributes are a little bit different. The people whom I know, and these are mostly federal, well, now I guess I know trial court judges in the state, but at least at the time I was sort of thinking about this, the people that I had a lot of experience with as trial court judges were federal judges. And, without trying to overly characterize them, part of their happiness seemed to be that they had a courtroom that they could run. And on a day-to-day basis, they didn't really have a boss. They didn't really have to work with anybody else except the staff that reported to them. And that isn't really me. I like working with other people who are at my level, who we discuss things. And I do this administratively, and I do this on the Court of Appeals. And when I said I like my Court of Appeals job best, That job, I don't think, has changed from when I was an associate judge to the chief judge. It really is the same job, and the fun of it is still in the back and forth discussion, learning, revising, writing. So to get directly to your question, I guess, for the job that I have on the Court of Appeals, which is an appellate job, Judge, the things that I like and I hope that I'm good at are taking things on quickly, understanding a factual record, knowing where to find things, knowing how to use that record, legal research, understanding how to distinguish cases or use cases, and then ultimately writing something that is hopefully persuasive. And sometimes, maybe oftentimes, it's a dissent, and you hope somebody will read those. But that's what I think I'm good at those things, and I think many of those things are things that I did as a lawyer.
So how important is it for you as a chief judge to try to build unanimity?
Well, I mean, it can be as little as important or not, depending on what your objectives are. And for me, I'd say it's not generally. Sometimes there is a case. I wouldn't even say a type of case, but a case where it really would be important for the court to be as unanimous as possible. But for the most cases, and I meant that, that case or that type of case is maybe 5%, maybe less than that. The rest of I think it doesn't really matter. I think it is kind of useful. And I've talked to Judge Lippman about this, and he and I have kind of the same philosophy about that, which is that dissent isn't a bad thing. The law isn't static, and it's useful for people to understand what the other side of some issue is. That may or may not become the majority, and maybe neither of those will prevail as the majority 30, 40, 50 years down the road. But to have those opposing writings is often better than a monolithic writing, particularly if the monolithic writing is a paragraph, which sometimes it is.
Are there judges, federal or state, who you try to emulate, folks that you admire?
Well, if I could write as well as Justice Robert Jackson, I would be really pleased with myself. I can't, but for writing, I would say he. For standing up for principles, I would say particularly when I was much younger, it was really Justices Brennan and Marshall, who I thought they constantly dissent every time there's a death penalty case. Clear the Supreme Court is not going to change its mind. Why are they doing this? And it was a matter of conscience, and I admire that and appreciate that there are times when that is really just what you have to do. Judge Weinstein, I wouldn't ever try to emulate, but he was incredibly creative. You know that firsthand. I don't know it only from litigating in front of him, but his sort of out-of-the-box thinking about things was refreshing, and sort of helped bring things to life a bit.
Right. My first day at work for him, we had a criminal case indicted as a crime family case by the U.S. Attorney's Office, where the magistrate judge had denied bail, and the defendants appealed the decision to Judge Weinstein. And he said, well, I understand that the Second Circuit has a presumption of violence associated with individuals who the government alleges are made members of a crime family. I disagree with the Second Circuit, so I'm going to give you bail. But I'm going to stay the bail for 15 days to give the government an opportunity to appeal my decision. And we get in the elevator, and my co-clerk, she was also fresh out of law school like me, and he said to both of us, he said, just watch, I'm going to get reversed on this within a week. Second Circuit reversed me on this, just 5 months ago. And she said, Judge, if you're going to get reversed, why grant bail? And he said, well, I think these men are entitled to bail under our country's constitution, and I want to give them bail. So, that's the type of courage I think that Marshall and Brennan and Jackson, going back to some of his dissents in the Japanese-American internment cases, had. Let's talk a little bit about your priorities as a chief judge. What is it that you're focused on? What is it that you think other judges, practitioners who are here today should care about and should also be focused on?
Well, I think the priorities have changed a little bit from day one. So day one, I think probably Judge Zayas and I agreed that the first priority was morale within the system. that it was low. The pandemic certainly responsible for some of it, but not all of it. The system being really under-resourced was a big part of it. And there were other factors. And so we thought, and this isn't just judges, this is everybody throughout the system, that if people aren't happy, they're really not going to invest themselves in their job. And so the first thing that we really needed to do was look at the various things that we thought or could learn about that were making people less than happy, making people who were employed by or judges in the court system less than happy, and try to address those things first. And I think we actually, in the first year, did a lot of things. And so that, I would say, is it important? Yes. Is that priority one right now? I would say no. I think the thing that I'm now trying to shift people's focus to I think sometimes it's been described, and I've described it as as sort of a problem-solving approach to everything that the courts do. But another way to think about it, I think, is to focus on the user experience. If we think of this instead of as kind of a traditional court, we think of it instead as a traditional place where people are coming and they have needs, and the institution, the business, whether it's a bank or a restaurant or whatever it is trying to serve the customers. Now, of course, some of our customers don't want to be there, which poses interesting challenges. But it's still, I think...
You have them captive.
Well, yeah, you do. Some of them. And that poses some challenges, but I think it is still important to treat even the worst people humanely. And it's not that everybody coming through the system is the worst people. A lot of them maybe are not bad people who did something bad. And there's, a whole civil side where, my experience is when you've got civil litigation, each side thinks the other side is the devil, and then they eventually settle something. So it's that kind of a focus, I think, is to think how we can, what I'd like is that, and this is of course never going to happen, but I would like is that when litigants, whether it's criminal, civil, leave and the court proceeding is done, they both think that even if they didn't get the result they wanted, or if they did, they were treated fairly. People being what they are, you're never going to get 100% of that, but if we can move that needle up, I think that's a big improvement.
So let's talk a little bit about the court system in New York and the myriad courts that we have within our system, for instance, housing, criminal, civil. What types of professional experiences do you think an ideal candidate would have or should have if they're applying or endeavoring to be a judge in some of these courts?
See, this is such a bad question for me to answer, but you've got so many people here who are expert in that. If you wanted to know what an ideal candidate for housing court would be, talk to Jack Stoller sitting back there. The courts are different, right? And so we had an interesting situation last year when we got a bunch of family court judges, and at literally the last minute, the legislature told us, for some of these judges in New York City, we're going to make them civil court judges instead of family court judges. And you can put them where you want. And we thought, well, why are you doing that? And the answer was because they wanted to take them out of the mayoral appointment and make them elected, because they didn't want Mayor Adams picking the people who were going to be his judges. And so what we then had to figure out was, we don't want people in family court as judges who don't want to be family court judges. We want people who really understand why family court is important and want to be there and want to enjoy trying to help families through these times, not people who want to be a civil court judge and got stuck into family court. And how are we going to manage this now that the allocations have been changed? And so we thought, well, one of the things we can do is we can go to the existing civil court judges and ask them, are there any of you who really would prefer to be a family court judge? Because we could move you over. And then also to try and make it clear through the various nominating bodies that if, these slots are actually family court slots, even though they're labeled civil, so, don't run unless you really want to be in family court. So there are challenges like that, but I guess I would say the most important isn't really even so much experience, although other people here are free to contradict me about that. It's enthusiasm and eagerness, willing to work hard and to learn. I would be a terrible family court judge right now, but in a year or two, I think I could be a pretty good family court judge.
So I hope that my next question complies with the current federal policy on diversity. The question is rather simple. What advice would you give to individuals from underrepresented backgrounds who are aspiring to be judges in our state court system? Is
What?
anything specific, anything different that they should do?
Well, I don't know if it's different, but I will say, sort of to put it in this kind of perspective, when I started out as an associate at Cravath, there were no partners of color there, and I don't think that any of the 20, top firms in New York City had African American partners, excepting Simpson had Conrad Harper, and Skadden had Vaughn Williams. And Amalia Kearse had been a partner, but was on the bench by that point. So there were just those two, I think. And so if I, as a brand new associate Cravath, wanted to go talk to somebody about what it was like and what I should expect and how I could move ahead and so on, I really had almost nobody to talk to. So if you go to, any like the Supreme Court Justices annual conference or the Family Court Judges or, any of the New York State Court, annual meetings, and you look around the audience, it's not like that. You can now find a lot of different people from a lot of different backgrounds. Even if you look at the Court of Appeals and ask, how many of these people had parents who were judges? No, you've got the daughter of Greek immigrants who ran a pizza place. I mean, you've got all kinds of people I had no lawyers in my family. And so you can find people who've had experiences that are like yours or that are, non-conventional. It's not like, there's 3 generations of judges in this family and that's how they got to become a judge. And my advice, I think, would be find those people. They're usually eager to talk to you. You can work for them. If you're a young lawyer, maybe you want to work for them as their law secretary. That's a traditional way to move through the system. There are others, getting involved with the local political clubs is a way to get yourself known. And, those are also more diverse than they were 20, 30, 40 years ago. I guess I'm dating myself 40 years ago now. But things are better.
So this is probably a good opportunity for me to recognize that our association, unfortunately, has its own checkered past when it comes to underrepresented groups. We've been around since 1870, and for well over 100 years, we did not allow Black Americans to be members of our association. We didn't allow women to be members of our association. We didn't have our first Black president until, I think it was 1992, when Conrad, whose portrait is right there actually, became the first Black president of our association. And the first woman president of our association is Barbara Paul Robinson, and her portrait is hanging next to Conrad's. But as the chief said, we have made advances in the profession, as demonstrated by the fact that you have a Muslim who is interviewing the first Black chief judge of the New York State court system. But that doesn't mean that the work is there's no work to be done. There's a tremendous amount of work that we can do as professionals, as lawyers, and perhaps as judges in promoting diversity in our court system.
Yeah, and I should say that from my perspective at least, there's a bigger problem with the way the court system treats diverse litigants than the way it is composed itself in terms of its makeup.
So, not speaking about anything that's happening at the federal level, but I'm wondering, Chief, if you can speak to the role that judges can play in promoting respect for the rule of law and ensuring that the executive branches, whether at the state, federal, international level perhaps, carry out judicial decisions, and whether these types of issues are a challenge for judges at the state court level.
So they're, at least it seems to me at the moment, less of a challenge for judges at the state court level, although today Judge St. George offered me and Judge Zayas to be added to the distribution of threats made to judges around New York State. He's got a big spreadsheet of that he follows, and we both said, okay, go ahead and send it to us, and I opened it up, and it's pretty long. Now, many of these threats are disgruntled, pro se litigants or that sort of thing, so I don't want to represent that these are actually people with guns. But the climate is different than it was, 10 years ago, 20 years ago, and that is something to worry about. But what can judges do? I think, Jack Weinstein would, I hope, approve of the way I think about this, which is it isn't limited to what judges can do as judges in terms of writing opinions that are clear and that are fair and that are thorough, and that, it's always, I think, been important to me that litigants can understand what I've written, and if you're a trial judge, a lot of things you're doing orally, but to take the time to explain why you're doing something and to listen and respond so that, and again, as I was saying, that even if they don't like the result, they understand why you got there. I think that's an important thing. But, and the part of it that I hope Judge Weinstein would approve of is there are things like reading Dr. Seuss, or like going to Rockland County, or giving 3-day law day speeches, one on the 30th, one on the 1st, one on the 2nd. I can't prove that any of those things will help the next generation be able to talk about issues and think about them in a more civilized, less polarized, more productive way, but I believe that. And that you don't have to be a judge to do that. You can be a lawyer, you can be a court officer, and our court officers do go to schools and they do talk about things. I walked my youngest daughter to school today, which I usually do, and as I was walking back, there was a group of high school students, I don't know from where, they were in front of a big bus right on Madison Avenue between 96th and 97th, and there were maybe 40 or 50 of them chanting the Gettysburg Address in unison. I don't know why they were doing that. I almost stopped and asked them, but I thought, well, this is actually civics, so I'm not going to interrupt. They're doing their thing. And that makes a difference. I mean, they at least, at some point in their lives, memorize some part of the Gettysburg Address.
So I'll share a quick anecdote about Judge Weinstein, which hopefully will segue into my last question for you. When I was clerking for him, he hosted middle school and high school students in his chambers to teach them about or talk to them about what it's like to be a judge. And this is when I think Justice John Roberts was going through his confirmation hearings. And one of the middle school students asked Judge Weinstein, do you ever let your personal experiences as someone, grew up at the docks in Brooklyn, someone who served in the Second World War and lived and grew up in the city, inform the way you decide cases? And I thought the judge was going to give a canned answer, which was, no, I'm here to call balls and strikes. And he said, how could I not? So, Chief, are there any personal experiences that you have that inform the way that you decide cases?
I'm sure that every personal experience I've had informs the way I decide cases. The problem is there's such a tangle, and they're not all one-sided, and it's the same thing as my not knowing whether talking to some group of students somewhere is ever really going to make a difference. I can't prove that, but I believe it. And I believe that everything that has ever happened to me in some way or another is influencing how I think about some issue. I will say that among the people I listen to besides my colleagues when I'm deciding things are my law clerks, and there's countless times when they've said, no, that's stupid, you can't do that, and explain to me why, and a lot of times they're right. So that's, again, a thing that happened to me that influenced me, and when, let's say, one of my law clerks the second year that I was a judge I had that experience, I think that probably influences me in the way that 4 years later, some other law clerk says something to me, that these things all ricochet off each other, but you can't count them, you can't weigh them. They're there. And so you can't worry about them.
Well, that was the last question I had. I think we can open up the floor for some questions from the audience, if that's okay with you, Judge?
Absolutely. Just, I don't want any judges asking me substantive legal questions.
Any questions from members of the audience? Question back there.
You made reference to the user experience, Rowan, and also those who are in the criminal part who may not.
So we get some of that through bar associations, sometimes formally in the form of reports or meetings that we have with them, and sometimes informally. You run into somebody at some kind of event, and we've tried to be very encouraging, the whole leadership team and the administrative judges, that if you've got a problem, you can sort of bring it to anybody, or an issue or a suggestion. About a year ago, I raised with Judge Richardson and others the idea of having suggestion boxes. And the first thought was, well, we could have suggestion boxes that were digital, and then everybody said, well, the problem with that is that even if they're anonymous, nobody's going to believe that. They're going to think that you can track the IP addresses of the email, so we can't do that. And so that kind of shelved it for a little while, but just last week, Judge Richardson sent me a note saying, I haven't given up on my suggestion box idea, and she had placed one somewhere, I've forgotten where she put it, in a courthouse. It might be 60 Center. And so I went onto Amazon and looked for something that, so what I found was a neon thing that says, think outside and it's in a square, and then the word box is outside of the box, and I sent that to her, and I said, why don't you put this on the suggestion box? So we may start rolling these out, not necessarily cutesy like that, but to get, because I think the anonymity that you alluded to is really important. I don't think you'll get very honest answers from from general users if they think that you can figure out who they are. I mean, we wouldn't ever try or do anything in response to that, but I understand the fear. And so that's one thing we're thinking about. And of course, if you have other ideas about how we might get, comments, things we can work on the civil side. I mean, we do get, for example, in the commercial division, the advisory group is very active. They send the administrative board proposed rule changes all the time. They, I think, do have their pulse on the more complex commercial litigation needs and keeping up with other states or staying ahead of them. But there's not a similar outfit for, then, like if you're trying to, for example, the tort bar has been repeatedly telling me that the time the appellate division is taking to decide tort cases is too long, and that they think that the defense bar on the personal injury cases is deliberately slowing the appeals down in the hope that some of the plaintiffs will expire before the case is decided. So, we get feedback from people. It's just not organized, generally.
Other questions? Wow, room full of lawyers, no questions.
Yeah, the law doesn't allow the employers to do that, so some of it is, I think, the judge calling, or I don't know if there's a way we can there's so many different employers that it's very hard. The bigger employers, I think, understand that. It's the smaller ones. And, to be fair to the smaller employers, if you run a little deli and you've got 3 workers and it's a busy place and one of them's got to go off on jury duty for a week, that's a hardship. I don't know how you find somebody to replace that person. Difficult. The pay is sort of a different thing. I think a lot of times people find that it doesn't cover their parking, and that not just here in New York City, and in Buffalo, I've been told, it doesn't. You can't park in Buffalo by the courthouse for the per diem. So that's how realistic is it we'll get that increased. I think that's actually pretty realistic. Senator Hoylman is a big proponent of that. It's something that we're pushing very hard, and I think we'll get that this year.
Perhaps just one last question. Okay, there's one over there.
So listening to what the judge asks, but you'd be surprised how many people don't do that. Answering, so even if you want to say a big answer or take issue with the question or that sort of thing, to give an answer and then say, but let me expand on that, or that, but the answer is yes, but here's the qualification, not this long qualification, and then you start getting prodded about what this was a yes or no, and you don't want to wind up in that situation. Knowing the record is important. Not misrepresenting things in the record is important. If you don't know something, don't make up an answer. People do that. They get into a lot of trouble, not necessarily on the spot, but sometimes they'll say something that is both incorrect and harmful to their client because it's something they're not prepared for and they're sort of improvising on the spot. One problem I always had as a litigant was speaking too rapidly. So slowing down a little bit is useful. In presenting your arguments, think about what order you're presenting them in and why you're presenting them in that order. Do you need as many arguments as you can possibly think of, or are there some that you really don't need to put in your briefs at all, can abandon, some that you can leave in your briefs but not focus on in argument? And then if you are the appellant, or if you were, however it is, you're the person who is going to end up having a chance to get up for a rebuttal, think very carefully about the 2 or 3 things you really need to say in your rebuttal. And when you get up, when it's your turn in a rebuttal, say, here are the 3 things that I want to talk about, 1, 2, 3, before you get to the substance of any of them, so that the court will understand there are 3 things. And so even if you run out of time or the court wants to move you along, the court will know there's something else instead of just cutting you off. Practice your argument, have other people critique it, moot it. That's useful. Even when I found myself in a trial court arguing a discovery motion or a motion to dismiss or so on, those are, it's just as useful to practice those and have others listen and pepper you with questions. Those are the things that come to mind, I think. That's a lot, but all of those things are things that I regularly see people doing incorrectly. And if I'm seeing that in the Court of Appeals, I'm sure it's happening elsewhere.
Well, thank you, Chief, for taking the time this
Of course.
evening.
Oh, thank you, Mohammed.